Marbury versus Madison staked out that territory, which has been respected and has been the norm ever since, that the Supreme Court does get the final word on whether something is constitutional or not, whether it is really consistent with the form of government that our founders adopted through the Constitution. But I would also point to a very famous case in the 20th century, mid-20th century, of course, would be Brown versus Board of Education, which there had been 1954, and that struck down the whole system of segregation and this whole concept of separate but equal. And that is something that had evolved in the late 19th century. In the 1890s, the Supreme Court had issued an opinion called Plessy versus Ferguson, and that involved, I believe it was in the city of New Orleans, where they were segregated streetcars provided for. And a black citizen complained that he was being denied his right to ride in whatever car that he wanted to, and he objected to the segregation. But the court in Plessy versus Ferguson said, as long as there are equal facilities,
that's separation but equal?
Separate but equal.
Yeah.
If the facilities that are provided for the race that is segregated away from the whites is equal, then the Constitution, that passes constitutional muster.